條例草案。
政府法案，本會恢復2019年司法人員延展退休年齡修訂條例草案嘅二讀辯論。條例草案委員會主席梁美芬議員先就委員。
The Honourable Priscilla Leung, Chairman of the Bills Committee on the Bill, will first address the Council on the committee's report. Dr. Priscilla Leung. President, in my capacity as the Chairman of the Bills Committee to study the Judicial Officers' Extension of Retirement Age Amendment Bill 2019, I report to Council the deliberations of the Bills Committee. The aim of the bill is to amend the High Court Ordinance, Cap 4, the District Court Ordinance, Cap 336, the Pensions Benefits Judicial Officers Ordinance, Cap 401, and the Court of Final Appeal Ordinance, Cap 484. In order to make provisions to provide for the extension of retirement age and terms of office of judges and judicial officers. The Bills Committee held 3 meetings. We also invited the public to give us their submissions. At the meetings, members generally supported the legislative proposals of the bill. And on the statutory retirement age of JJOs, the early retirement age and also discretionary early retirement, discretionary extension of service, and also the transitional arrangements for the smooth implementation of the bill, all that was discussed by the BC, and I will now tell you the gist of our deliberations. The Bills Committee is of the view that extending the retirement age and terms of office of JJOs will only address part of the problem of a shortage of manpower at the judiciary. Members asked the administration and the judicial administration to take out the measures, for example, to improve the remuneration and conditions of service for JJOs in order to address the manpower shortage problem. Some members were of the view that extending the statutory retirement age for JJOs below the CFI level might help to attract more legal personnel in private practice to join the judiciary and retain experienced JJOs. However, the judiciary was of the view that setting the retirement age for these JJOs at 65 would mean that it would not hinder the advancement of junior officers who are suitable for elevation. It can also help to inject new blood. Some members said that we should explore the feasibility of relaxing or lifting the prohibition against judges' return to private practice as barristers or solicitors, because such prohibition might discourage some legal practitioners from joining the bench. The JA stressed that this established practice aims to maintain judicial independence and command public confidence. It therefore disagreed with relaxing the prohibition. On the other hand, the maximum retirement age for judges of CFA, the Court of Appeal, CFI, under the discretionary extension arrangements may be up to 76, 75, and 75. Those of JJOs below the CFI level, the statutory retirement age may be up to 70. Some members are concerned about JJOs on extended terms of office becoming incapable of carrying out their duties for health reasons. Other members pointed out that this would increase manpower for the judiciary and it should be supported. However, during the extended tenure, judges should focus on judicial duties and not be responsible for management or administrative duties. And some members have proposed that a mechanism should be set up for the JA and JJOs to, during the extended term of office, mutually review on a regular basis whether the extended term should continue. Some members also proposed that consideration be given to allowing such JJOs more flexibility in their workload and working hours. In making its response, the JA said that before a discretionary extension of term of office is granted, the JJOs concerned will be required to pass a medical exam to ascertain that they are medically fit for continued employment. JJOs mainly perform judicial duties, the JA said. Only a small number of them perform administrative duties. Furthermore, besides continuing their services through discretionary extension arrangements, retired JJOs may also consider serving as deputy JJOs who only work on a temporary basis. The administration and the JA have responded to the legal and drafting issues raised by our legal advisor. The Bills Committee supports the resumption of second reading debate of the bill. The BC will not move any CSAs to the bill. The details of the work of the BC are in the report submitted to Council. President, now I will talk about the bill. My view is that I support the extension of retirement age of JJOs. This is because in certain areas, especially in law and social sciences, age will mean that people are more experienced in life and they would have richer experience in passing judgment and writing judgments. So nobody actually objects to the extension of retirement age. In international courts, some judges are at the age of 87. The important thing about implementing the law is quality. At present, the JA is proposing to extend the retirement age, and one of the main reasons is that there is a shortage of manpower, and I'd like to discuss this. We are of the view that extension of the retirement age of JJOs will just address a very small part of the present system at the judiciary. And we hope that this process will not be automatic either. I hope that the judiciary leaders will give consideration to the extension of age of each JJO, the judge's character, the credibility, and continued performance should all be examined. As I said, the JJOs themselves would also consider their own competency and health condition. But then in present-day Hong Kong, neutrality and credibility are extremely important. I'd like to speak on the following issues. First, in the process of extending the retirement age, then perhaps you should show the public that you do not do it in a light-hearted manner or automatic, but that there is a process. Number two, now there is a huge shortage of manpower. Many people are of the view that people wait very long for a case to be heard, and this is not in line with the public's expectation. I would explore this point. At present, credibility and neutrality are of concern to Hong Kong society. This is because in the middle of the year, near the end of May and beginning of June, we saw some events not desired by us. 3 judges anonymously told a newspaper in public their worries about the amendment to the FOO, and it's clear that they were objecting to the bill. And one judge actually signed a petition. And we could see that his name was indeed the name of a judge, and indeed it was confirmed that he was a serving judge. So people could rightly ask, when these judges sit in court to judge certain cases, which may involve people who adopt a high profile in supporting the bill, then can these judges remain neutral? With regard to the judge who signed his name, well, I think it's not appropriate. But I would say that actually he showed some commitment because he revealed his identity. And then people could, of course, then ask him to recuse himself from certain cases. And the judges can require that to be done as well. Sometimes the parties may ask the judge to recuse himself because of a conflict of interest or because he is a relative to a certain party. But what about the anonymous judges? One anonymous judge may worry people enough, but now there are 3. Are they junior judges or are they senior judges? How should we do any vetting if they are anonymous? We asked this question at the Bills Committee, and would these judges also be extending their retirement age? President, we understand that investigation is extremely difficult because of anonymity. Even at the council here and the university I work in, we sometimes do have to investigate into people, anonymous people, who may leak secrets. And now judges should maintain their political neutrality so that whatever political stance you have, you must be seen to be credible. So how can we do the investigation? Of course, we can try our best. Sometimes, as select committees set up under the Legislative Council Powers and Privileges Ordinance, if some people leak a secret, then all our members will sign a statutory confirmation saying that he or she is not the one who leaked something. Many people refuse to sign because they know in their heart what they have done. If it is a judge, he should know better that apart from shouldering moral responsibility, this person should also face a legal consequence. It's not easy for you to sign that kind of statutory confirmation because that would amount to lying. But at least we should go through this process. If we don't do it, then the judiciary cannot be accountable to the public as to what cases these 3 judges are judging. People who read law know this very clearly. The goddess of justice has her eyes covered, meaning that her political stance should not affect her in any way. Of course, judges are just human and they are entitled to their own political views. But judges should not express that in public, all the least in an anonymous way. And of course, society may have the impression that judges are opposing to the bill, but they do not have to face legal or other responsibilities. We think this is extremely undesirable. And then this leads on to other issues. Actually, we have nothing much to say about the extension of retirement age, except what we said at the BC. We also consulted other public organizations as to whether someone holding a high position should be re-employed after retirement. It's just like in university, it may be the dean of a faculty and he may be re-employed as a professor even if he may not be involved in any administrative duties. And this person can concentrate on his professional side. President, I respect and very much appreciate Chief Justice Jeffrey Ma, who stated very clearly a few days ago that he would retire as scheduled in early 2021. I understand his ways. He wants this to be realized, and he wouldn't like to be extending his own retirement age. I think that is what he doesn't want to do, and that is why he is not requiring or requesting an extension of retirement age. I respect his decision. In the past 10-odd years, I think he has been pivotal in leading the judiciary, and I like to register my gratitude to him. He has been very proactive in pushing for extension of retirement age of JJOs, and we support it. But then I have to point out that when we seek to attract new blood, and I'm coming to my second point, I'd like to talk about the mechanism and the way to do it. I think you are not meeting the needs of society. This morning, I have got the latest figures. Right now, there are 6,000 claimants of torture claims, and they are lining up for judicial review. I thought there were 1,000, but now I know there are 6,000. And then there are still 1,000 cases with regard to the occupation movement, and there are over 3,000 cases about recent unrest. And we need to have the views of the court quickly on these cases, because justice delayed is justice denied, especially with regard to Occupy Central, the Mong Kok riot, and the recent social unrest. These are major events in society, and society expects the judge, the judiciary, to let us know the bottom line of our legal system. And if the judiciary has spoken, young people may know that they should not trust it to luck and try to break the law. However, the Occupy Trio case is still being appealed. And what about the recent riot cases? Do they have to wait 5-10 years? The UK is a common law country, and we have been learning from it. In 2011, the UK decided to bundle together riot cases. The government and the courts thought that it was a matter of public interest. The courts there could work in tandem for 24 hours a day, for 7 days a week. And they are judging these disorder-related offense. After the riots, the first court remarkably heard 1,000 defendants. That was just the first hearing. This is because, Ms. Priscilla Leung, why is this point related to the bill? It's very important, President, because at present, you are only extending the retirement age of judges, and you are not addressing the problem. I must point it out here, and we mentioned it in the BC. I think I'm responsible to explain this to the public. In terms of public interest, Mr. Cameron said that he would not allow huge numbers of people arrested and having to wait long for court hearings. He said courts should sit through the nights as long as is necessary, because to young defendants, if they are to wait 3-5 years, and then if they are convicted and they are sent to prison for 5 years, that would take 10 years. If the case is finished within 2 years, then it's fairer to them. And I'm not talking about our political stance. This is about the entire society. Young defendants would need you to tell them what would happen to them, and law-abiding citizens would like the court to speak up. And after the courts have heard cases, if it is about children of the age of 8, 9, 11, and who are really innocent, and if they truly are remorseful, well, the UK said that there was this girl who is 11 years of age. She knew that she was in serious trouble and she would be arrested. But then she said she never thought that she would be caught and would be subject to court hearings. So the UK adopted this approach. And in Hong Kong, we do lack resources in terms of JJOs. If we want to learn from the UK, we should learn from it in total. I have been teaching at City University for 30 years. In Hong Kong U, the law school was set up in 1969 and the Chinese University 2005. Every year we have about 900 graduates qualifying as lawyers, and there are many experienced lawyers, and you should show some sincerity in luring them to join the bench. I think you have been less than proactive, and you are not giving the impression that the judiciary would really want them to help. And perhaps in these 2 years, you should seek to increase manpower, particularly for Occupy Central and torture claims and also riot-related cases. Entire society will suffer if you drag your feet. President, I hope the court would redouble its efforts to face up to this problem of manpower shortage. Ms. Starry Lee.
The problem of shortage of judges has been well known to the public at large in Hong Kong before, or at least since 1997. Hong Kong's shortage of judges means justice is often delayed. As was pointed out by former top official of the Department of Justice, Mr. Granville Cross, it was said that retired judges were being recorded to fill vacancy at the judiciary. Yet, even so, this could only be a temporary solution. It was also pointed out that we may once again have to turn to overseas recruitment. Since 1997, the judiciary has been faithfully upholding the rule of law, ensuring that not only justice is to be done, it must be also seen to be done with the independent judges on the bench, for which most of the Hong Kong people should be grateful. Of course, the judges required must always be those of the right quality. It was once reiterated by Chief Justice Jeffrey Ma that it is better to leave positions vacant than to have appointment of persons not of the required standard. In about March 2015, it was announced that out of 200 judicial posts, only 169 were filled substantially, and there have been persistent recruitment difficulty at the High Court level. It was reported by the South China Morning Post at about the end of 2015 that in the 3 consecutive recruitment exercises for the Court of First Instance held in 2012, 2013, 2014, not all vacancies were filled. The number of candidates suitable for appointment was much, much lower than the available vacancies. The Judiciary Administrator recently reported that there were 10 judicial vacancies in the Court of First Instance, on top of which a significant number of the existing judges will reach the statutory retirement age of 65 within the next 5 years. Many Court of First Instance judges have traditionally come from the district court or the legal profession, whereas newly appointed district judges may currently lack the experience necessary for promotion. A 2010 benchmark study showed that the pay of the Court of First Instance judges was lower than that of the legal professional of comparable experience in the private sectors. Remuneration, not of very attractive concern, coupled with the lower retirement age and the barring from returning to private practice, would undoubtedly keep any potential candidates from coming forward to join the bench. It was described by the South China Morning Post that although the pay and service condition of the senior judiciary, which are not ungenerous by international standards, are closely monitored by the Judicial Committee, an independent body, And various reviews are currently underway on judicial needs, including one on benefits and allowance. Abnormality remains. It is surprising, for example, that the Chief Justice is paid less than the 3 Secretary of Departments, notwithstanding his central role in the legal system. To combat its shortfall, the judiciary is calling retired judges coming back into temporary service, temporarily promoting district court judges, and relying on senior lawyers to sit as deputy judges or recorders for several weeks and years. While this may provide a short-term palliative, it is no substitute for substantive appointments. The Judicial Committee has recently advised that the judiciary's increasingly heavy workload has been particularly borne by those serving in the High Court, and the shortage of Court of First Instance judges presumably places existing judges under even greater pressure. The judiciary, moreover, in its annual report for 2014 indicated that its performance targets were not always being met. It confirmed once and again that the waiting time for a criminal case from the filing of the indictment to trial in the Court of First Instance was 227 days, whereas the target was 120 days. While there may be a reluctance on the part of judiciary due to the trend of localization to recruit overseas judges, a practice which was common before 1997. This option may have to be reconsidered if the present condition of the shortage of judges remain or deteriorate. Although Chinese is being increasingly used in the court cases, lower courts in particular, the basic law provides that English is also an official language of the judiciary. Yet the bulk of magistrate courts cases are now tried in Chinese. Many Court of First Instance trials are still conducted in English, and this is unlikely to change, at least not within a foreseeable future. Judicial shortage will also pose threat to our court system. As one of the UK top judges earlier warned, the UK's experience, as it is being one of the leading common law legal systems, is certainly well worth the serious consideration by Hong Kong, which is running the same system. The effective operation of the courts in England and Wales was under threat due to problems of judicial recruitment, increasingly heavy workloads and deteriorating working conditions, according to the Lord Chief Justice in his first appearance before the Lord's Constitution Selected Committee in his new post. The current difficulties with judicial recruitment pose a threat to the discharge of the business of the court effectively, as was pointed out by the most senior judge in England and Wales to his peers. This affects the ordinary work of the civil, family, and criminal courts. Additionally, problems of recruitment to the High Court threaten to undermine the worldwide reputation of the judiciary of England and Wales and reduce the attraction of London as the preeminent center for international dispute resolution. The voluntary use of the UK court by those outside the jurisdiction is worth billions a year. In Israel, the shortage of judges that has worsened over the years has led to a serious deterioration in the operation of Israel's judicial system. The 3 main areas were affected by the shortage. The first area is the judicial system itself, where the shortage is the primary determinant of the delay and what the public often prescribe as procrastination plaguing Israeli courts. Second area affected is due process. The shortage has led, in tandem with other factors, to inefficiency in the judicial system, compelling it most prominently in the last decade or so to be innovative, that is, introduce procedures devoid of any legal footing. Third area affected are judges themselves. It was advocated in Malaysia that to remain and sustain judicial reforms, it is necessary that the age of retirement for superior court judges be extended from 66 to 68 or 70. If there is reluctance to extend the retirement age of all superior court justices, a beginning can be made with the federal court. It is not uncommon for the appellate court to have a higher retirement age. In the Supreme Court of the United States and in constitutional courts in Austria and Greece, judges are appointed for life. In Canada, the retirement age is 75. In Belgium, Denmark, Israel, and Netherlands, Norway, and Australia, the age is 70 years. In Germany, it is 68. Increasing the retirement age in Hong Kong courts will bring many advantages. It will bring the present judiciary in line with the norm worldwide. It will permit continuation of a strong talent pool of experienced judges. Judicial reforms recently introduced will have time to get entrenched. It will make post-retirement assignments handed down by the executive become unattractive. This will improve independence of the judiciary and strengthen the rule of law, both of which are crucial to sustain democracy. The growth of cases in Hong Kong, civil or criminal, the commercial disputes, local or international, is alarming. While the recruitment, the training and engagement will inevitably take time, efforts and resources, the extension of the retirement age of judges, as proposed by the bill, does appear to be constructive and beneficial to Hong Kong. By this legislation, Hong Kong's judiciary will raise retirement age for judges by 5 years to 70, and the move will include pay rise for judges to counterbalance any shortcoming for these judges, as the sector of these judges face competition from the better paid private sectors and retirement. Now also by this legislation, the judiciary pushed back the retirement age for judges from 65 to 70 in a bid to tackle the persistent manpower shortage in the local courts, and an increasingly brain drain by the greying bench, as the press earlier described. The effort may trap the talent pool of the city's prosecutor's office to attract those eyeing a career change, as they may more likely to switch over than private lawyers who could not put off by a huge pay cut. Retired judges Wu Guoheng did first officially thrown hat in the ring for the Hong Kong's 2017 chief executive election. He tenders himself as a retired judge for possible further service as a chief executive in Hong Kong 2 weeks after the Executive Council has approved a proposal to offer judges of all ranks to pay rise plus extra allowance. It was an attempt to close the expanding pay gap between the judges and legal practitioners, which is one of the concerns for the latest in contemplating a job in the judiciary. The announcement in 2016 revealed a bleak reality, as a court of first instance judges in 2015 earned 60% less than a private practice senior counsel with the same experience. The pay gap was only 43% about a decade ago. The judiciary has since about 2012 increased the number of recruitment exercises for court of first instance judges, but to no avail. These judges, who earn about $255,000 a month, remain difficult to recruit, whereas those in private practice can charge clients tens of millions of dollars per annum, which, well, of course, I don't think, well, I hope fee can be lower. Until March 2016, only 162 out of 200 court posts were filled on a permanent basis, which is 7 down from a year earlier due to retirement. Another deterrent for lawyers, yet people can still be very smart, energetic, healthy, and capable in their late 70s. Although retired judges are entitled to pensions, those above the district court level are barred from returning to private practice after stepping down from the bench at 65, whereas their counterparts in the private sector can work for as long as they want. The former Law Society president, Thomas So, said he supports raising the retirement age and increasing judicial salaries. Hence, the solicitor, who has also been a deputy judge, said he could consider joining the bench later in his career. Former Bar Association President Winnie Tam also gave her support to the idea of postponing retirement for judges, and she wrote a column in the Chinese language newspaper Mingbo, stating that for many senior counsel who decide to make the switch, it will be a point of no return. A veteran barrister who preferred to remain anonymous suggests that the extended retirement age be made discretionary rather than mandatory. The former director of the public prosecution, Grenville Courts, also noted that while a pay cut may deter private counsel from joining the bench, the terms and conditions were actually very attractive to the Department of Justice prosecutors, who are already committed to the government. He opined that this tend to get better by the year, and the move to the judiciary is viewed as a logical career move. As he almost joined the High Court in the 1990s, but he said he was too much in love with the advocacy job as a prosecutor to make the switch. He said it would help if the judiciary could take advantages of the prosecutor's talent pool, especially because the retirement age for prosecutor is 60, while that for judges is 65. Other senior lawyers, the press spoke to raise other concerns. For instance, judges, especially those above court of first instance level, are so overloaded with work this day that they had hardly have time to write judgment. A job aspect widely considered by many as a primary source of job satisfaction, a way to contribute to the development of the common law. All in all, from all branches of the legal profession, it has come to a clear consensus and opinion that extending the retirement age of the judges is not only needed for addressing the issue of shortage of judicial manpower.
請你停止發言。會議現在暫停，明天9時。
Meeting is suspended until 9 tomorrow.